today's case, we're dealing with a decision from the Court of Appeals for the D.C. Circuit regarding the FAA. The FAA recently put in place a regulation that requires all drones above about a half pound to have a radio beacon on them so that they can be seen on the radar and things like that as part of the air management. And so someone challenged this in federal court, and the court has decided that, yes, this regulation is valid. So yeah, that's going to be a thing that's going to be happening. So let's discuss this and law as it relates to it. The FAA's remote ID rule responds to development of sophisticated yet inexpensive drone equipment, which has allowed for hundreds of thousands of new operators to enter the aviation community. Drones' growing ability has unlocked a large recreational market, both for factory and homemade models. Of 865,000 drones registered with the FAA by mid-2022, 538,000 of them were for recreational use. So 538,000 for recreation, 300,000 maybe for commercial purposes. The rapidly accelerating commercial uses and planned uses of drones include infrastructure inspection, real estate photography, and agricultural management. Universities use them for research. The healthcare industry uses drones to deliver medical supplies, whether to quickly traverse high congestion cities or reach remote areas lacking other viable transport. Government at every level increasingly relies on drones' distinctive capabilities, from tasks ranging from search and rescue to border patrol. Public and private emergency responders alike have used drones to observe hard-to-reach accident sites, monitor natural disasters, and assist in research and recovery. And plans are afoot for major expansions of other routine drone uses, such as express packaging, shipping, and delivery. So yeah, drones are a thing. They're a big thing. They're everywhere. They're increasing in size, in scope, in role, and the problem is increasing. So all the while, this increasing drone usage makes more air traffic. And the features that make drones so popular presently present novel and complex challenges to smoothly integrate the drones into 29 million square miles of U.S. airspace that tens of thousands of commercial and private aircraft also share every day. Congestion increases the risk of drone collisions with other aircraft, especially helicopters or other agricultural aircraft flying at low altitudes, and aircraft taking off near airports, landing strips, or heliports. This has definitely been a thing. It's been a thing that's been a problem. People flying drones near airports and collisions, even with planes, from time to time with these aircraft. Yeah. And there's a risk. Like, this is a growing problem. The FAA is aware of the problem. It's like we have a duty to manage the airspace. The airspace just got a lot more crowded. So why are we using remote ID? Well, according to the FAA, without that, we'd have to use visual inspection to avoid collision of drones. And manned aircraft were likewise left without any electronic data on the location of drones. So all we would have is visuals. And there's a lot of them and growing numbers. Drones' technical capabilities of flying at night over people and beyond operators' line of sight pose additional risks associated with lack of situational awareness, including collision with other aircrafts and objects, falling on and injuring people, and straying into private or sensitive areas. Safety concerns pertaining to national security and law enforcement are intensified when unidentified drones of unknown origin and intent fly over airports, public facilities, energy production infrastructure, sports stadiums, or other open-air venue where the concentration of people is high or the ability to damage things is significant. So yeah, these things are kind of everywhere. They pose threats. They pose all kinds of problems. We're concerned. Errant drone flights are not unusual. They are not. In 2019, the FAA alone received an average of 6 reports every day from people who claim to have witnessed unauthorized drone operations. The FAA has noted the potential use of drones for illegal activities, including carrying and smuggling of controlled substances, illicit drugs and other dangerous activity or hazardous payloads, the unlawful invasion of privacy, illegal surveillance and reconnaissance, the weaponization of drones, sabotaging of critical infrastructure, property theft, disruption, and harassment. T in Tennessee says, question on drones. Theoretically, if one falls in your fenced backyard and you have 4 boxer dogs that thought it was an invader and destroyed it, would you feel obligated to replace it? Would I feel obligated? Not particularly, no. Extremists have increasingly sought the use of drones to carry out violent attacks. Terrorists have killed people by detonating bombs carried by drones that flew above a military parade in Yemen. The Islamic State and other terrorist organizations have reportedly modified commercially available drones to carry and release munitions and explosives. A would-be assassin used a drone to target the then president of Venezuela. And British intelligence agencies have uncovered terror plots to fly drones into engines of commercial airplanes as they took off from airports in the United Kingdom. So there is a growing threat profile of these things from both innocent and not so innocent uses. And so the FAA obviously has some sort of interest in being able to try to do something to manage this airspace. They may not be able to stop every threat, of course. No one necessarily can, but they have some interest in being able to deal with this. So that's their concern. Congress also shares this concern, incidentally. Congress has responded to this by enacting laws to deal with these issues. In late 2011, Congress directed the FAA to establish drone test sites. In 2012, it called on the FAA to create a system to regulate operation of small drones and integrate them into the national space. So 2011, 2012, 10 years that FAA has been dealing with this problem. The FAA promulgated a series of comprehensive set of regulations in 2016. At first, Congress expressly excluded model aircraft or small drones used strictly for hobby or recreational use from its initial drone regulations. So Congress said initially that wasn't a concern. But rapidly increasing drone use and associated complexities prompted further congressional action, laying out the foundation for the rule here. The FAA Extension Act of 2016 directed the FAA to develop the capability to remotely locate drones in flight and contact their operator as needed to ensure regulatory compliance. So Congress says, FAA, yeah, this is a concern and we're concerned, so go fix that problem. And then the FAA Reauthorization Act of 2018, Congress tightly curtailed the statutory exemption for small hobbyist drones and made it clear they're generally subject to the same rules regarding registration and marking, remote identification, and maintaining safety and security as applied to other aircraft. So Congress has given the FAA more and more authority to deal with this increasing problem because of all the incidents that we're seeing. So the FAA has complied with Congress's call by requiring this remote identification program starting in January 2021. This would provide, according to the FAA, airspace awareness to the FAA and other law enforcement agencies to help manage the airspace. The remote ID rule was the product of a year-long public rulemaking in which there were 53,000 comments. A lot of people had thoughts on the issue. The remote rule becomes effective as of September 16th, 2023. So it's not in effect yet, but it's coming into effect in about a year. And it will require non-military drones weighing over 0.55 pounds to be registered with the FAA and have signaling information in flight. So this is an upcoming regulation in play. So as of September 16th, 2023, every drone that weighs more than half a pound will have to have this signaling information as part of its operation. So that will require drones to be altered that currently exist, and of course, new ones that go on sale to be altered. Drones must emit the remote ID signal when the drone is in flight, from takeoff to shutdown. The requirement is inapplicable if the drone is entirely indoors, underground, or inside in a closed space such as a netted enclosure. A standard remote ID drone in flight must continuously emit the following information: its unique identification number, its latitude, longitude, geometric altitude, and velocity, latitude, longitude, and geometric altitude of the drone's control station, the time, and any applicable emergency status, such as it's down, low fuel, low battery, or other abnormal situation. So basically, it must continuously broadcast its serial number or other identifier, unique identifier, where it is, how fast it's going, what direction, and where the person who's operating it is located. So those are the things that must be broadcast continuously from the drone. The unique identification number is the drone serial number. A drone owner must register the serial number with the FAA along with name and contact information. Access to this information is strictly limited to the FAA by law. So it's not subject to public disclosure. It's not subject to Public Act requirements. It's not subject to open records law. So it is available to the FAA and government, but not available through sunshine laws, for example. Okay, so with all those regulations in place, we understand the framework of what we're dealing with. right? There are a lot of drones. Since 2011, the FAA has been tasked by Congress to deal with the drones in increasingly escalating steps by Congress. Congress has passed new laws giving the FAA more and more authority, which is what you want to see, right? You want to see Congress doing this rather than the agencies just doing this. So if someone's going to do it, Congress should do it. Congress is doing it. This is good. This is the way law should work. Great. Congress is passing law. That's helpful. All right. So they've been increasingly tasking the FAA with this authority. And the FAA said, okay, basically we want all the drones that are more than half a pound to have this continuous broadcasting authority. So this guy over here is suing, saying that's illegal. It's invalid. All right. So what does the court have to say? As to the Fourth Amendment, it's hard to see what could be private about flying a drone in the open air. I mean, yeah. Activities that require privacy are not typically conducted aloft. In contrast to how we use homes, cars, and cell phones, people do not ordinarily live in or store private objects or informations in their drones. Yeah. Rather, as with cars traveling on public streets and highways or helicopters taking off, drones in the skies ordinarily make themselves visible to anyone who can see them. And a drone pilot who elects to fly outdoors puts an aircraft into airspace used by other users who also have an interest in the use of the public space. So yeah, not so much with any right of privacy. Your reasonable expectation of privacy under the Fourth Amendment is looking pretty dim since it's in the open air and anyone can look at it. The FAA says the remote ID rule does not invade any reasonable expectation of privacy because aviation is extensively regulated, and because the rule only applies to drones flying outdoors. Yeah, by its own terms, that's what it says. But by the same token, identifying airborne location of aircraft and co-locating pilot with a transponder is not a Fourth Amendment search. You're out in the open for anyone to see. It's a highly regulated aspect. Air travel has been pretty highly regulated for about 100 years. So yeah, not so much. The facial challenge to the Fourth Amendment, saying that this is an invalid regulation, fails because there is no reasonable expectation of privacy. A search would occur when a government action interferes in a sphere an individual seeks to preserve as private. But you're not even trying to keep it private because you're out in the open. They do not dispute that it's generally visible to outlookers in the sky. Yeah. Drones fly in the open, and what is sometimes called in the open fields. Open fields beyond the curtilage of a home are not among protected places. This is pretty classic Fourth Amendment law. Yeah, and to the extent that you are within the curtilage, once you're flying above a certain rate, right, once you're in the navigatable airspace, then, that's subject to regulation. This limited local real-time information required by the rule is a far cry from continuous surveillance the Supreme Court has held violates a reasonable expectation of privacy. So there's a case called Carpenter, which dealt with the collection of cell phone records. In Carpenter, the government accessed 127 days worth of cell phone records, which provided near perfect surveillance for 127 days. Because the cell phone is on basically all the time, everywhere, continuously, right? In Jones, the privacy invasion arose from them putting something physically onto your car, right? No physical trespass is asserted here because, again, this is different than a car because it's part of the navigatable airspace. And unlike a cell location data or GPS tracker in a car, it's unclear how this could be used to place anyone at the scene of a robbery because you're flying, it's how would that put you at the robbery? Your drone maybe, but it's also supposed to know where you are. Also, because the drone is only broadcasting its location when it's flying by the regulation, right? According to the regulation, it's only broadcasting its location between takeoff and landing. So if it's on the ground, not so much. When it's off, not so much. This is quite a bit different than the concerns the Supreme Court was trying to raise in Carpenter and Jones. The court, however, does note that this is merely a facial challenge, right? This is a challenge to the face of the statute. That doesn't necessarily preclude an as-applied challenge. So the court, therefore, explicitly knows they are not foreclosing the possibility of declaratory judgment or injunction by a party that establishes as to their own particular use that would violate their rights. So this was a challenge to the entire regulation, a facial challenge, right? It's invalid on its face. As to all applications, the court's like, no. But the court's like, okay, maybe there is some sort of as-applied challenge. They're leaving open the door at least, right? So maybe someone will come along with a case that somehow shows it's invalid as to them. We're leaving that door open, but as to this is invalid on its face, no. Thus, that brings us to the end of the case of Tyler Brennan and Race Day Quads LLC versus the FAA. The FAA has adopted regulations pursuant to statute by Congress. Congress actually passed laws. I know, it's amazing, but it does occasionally happen. And Congress apparently over the last 10 years has passed a couple different versions of the law in increasingly escalating steps. Congress apparently is concerned about this, and there seems to be some concern because people are flying these things and it's clogging the airspace. And the FAA says, wait, if these things had a radio beacon on them and then they could be detected, within so much distance, like if they broadcast their location and the broadcast goes for like a mile, because that's part of the decision, by the way, in terms of like it goes into the unregulated bandwidth in terms of the space, like goes into the industrial space. So it's only broadcasting for like a mile. But if like within a mile you can determine that this thing is happening, then great. So that maybe people can use that in some way. It's part of a series of measures. I doubt the last one, and there may be more invasive measures coming down the pipe, I'm sure, because these things are creating some problems. They're creating problems with people flying these things in ways that are invading people's privacy, creating harm to pilots, creating harms to aircraft. It's happening, and this is only going to escalate. As technology continues to get better and better, drones get cheaper and cheaper, more and more capable, this is going to become an increasing problem. So the FAA is trying to catch up as best they can. So yeah, this might violate someone's privacy in some situation, but on the face of it, no. The FAA did exactly what Congress told them to do. So yeah, starting in September 2023, all drones that are more than about a half pound will have to have a radio beacon on them. They'll have to be retrofitted or otherwise. So, go do that. That's part of the regulation. So, that's that. And at least for a moment, that brings us to the end of discussion of this case.